Hello, everyone, and thanks for joining us for our Instructor Development Workshop for the 2020-2022 core course titled A Walk Through the Law. I'd like to thank the South Carolina Real Estate Commission for allowing us to present the instructor training to you in this format while everyone is social distancing. I'd also like to thank the Western Upstate Association of Realtors for allowing us to use their fine facility located in Anderson, South Carolina, in order to do the videotaping today. I'd like to introduce you to the co-host of the instructor workshop, Carol Simpson, who's going to be doing the training for you. In addition, your South Carolina Real Estate Commission staff will be sending information to all of you as instructors and course providers on how to get approved to be able to teach this course starting September of 2020. So thanks again for joining us and welcome to A Walk Through the Law.
Thank you, Diana, and I'm excited about this course. I mean, really excited about this course. As my name is Carol Simpson, I practice law in Greenville, South Carolina, and as a lawyer, a real estate attorney, so often I get questions from realtors that are asking things that I think, have you read the license law? Well, after this class, they're going to be able to say, I've read most of it, because this is truly a walk through the law. I also thank the LLR for putting this course together and allowing it to have so much law in it, but this is crucial. I'm excited. I hope you feel that way at the end of this. All right, to receive credit for this course, of course, you must have signed in at registration so everyone knows you're here. You have to remain in the class the whole time except for scheduled breaks, and we will have scheduled breaks. At every 50 minutes, we'll have those breaks, so don't worry about that. You have to participate in all class activities, of course, and at the end, you'll receive a certificate of completion. As we'll touch on in the course, which you probably know by now, all providers have to upload hours to cebroker.com, so the renewal credit will be there automatically with the Real Estate Commission. And this course does meet the 4-hour mandatory core requirement through the 2022 renewals. Okay? So if we're going to go through and talk about walking a trail, where is that trail? Where do we find it? Well, we find it in the South Carolina Code of Laws. You'll hear me refer to this throughout, instead of Code of Laws all the time, as license law. So let's find that trail. Log on to your Real Estate Commission website, the South Carolina Real Estate Commission website. That's at www.lr.sc.gov/RE. Okay, it's right there on the screen for you. Need you to take a second and log in. You can go through that. The PowerPoint will have some slides about the Real Estate Commission and some of the various things we're looking at, but we're actually going to go to the website. Let's take a second and everybody get to the website. Brand new look to the website, at least brand new for some of us. It's really nice. It's easy to navigate, and that's what we're going to spend some time doing now, is navigating this website. So you sign on. Before, you obviously can read license law, other than you have your materials before you. In the past, you would need to find license law. So let's just look through here, the Real Estate Commission, a little bit, and what we have. You have the home page, and the home page is particularly helpful because not only to have buttons for you to click on, but over here to the right, it has the quick links. And with these quick links, you can get to the things that you need to get to from any page. So if you always, I hate to get stuck on a page and not be able to figure out how to get where I want to go. Here we have a whole lot of alerts. Of course, with this, it has all the alerts for when's closed, what's closed, when it's closed, etc. But here's your core part. These are your basic. What page do I want to get to? Well, it depends, of course, on what you want to do. If you want to make an application, you go to applications. If you want to find forms, you go to forms and resources. We're not going there, but as we go through the course, we're going to speak about some of the LLR mandated forms, the ones you have to use. Well, you would find those by going to forms and resources. But we're here to find license law. Let's go to law and policies. Okay, go to law and policies, and lo and behold, here we have on website another page. Again, easy to navigate. We just have buttons to click on. You can see there's a lot of different law and policies here provided for us. And again, notice over to your right are still your quick links. So if you say, oh, I didn't mean to go here, I want to go somewhere else, I want to change my address, you can just click on change your address over there. We actually do want to go to license law, so we're going to click on license law. And after doing that, everybody's computer takes a minute to load. We come up with license law. Now, the license law that's on the website is going to look a little different. Mine's still loading, but it's going to look a little different than what you've printed. We have printed. We've actually taken, this is the bill that was enacted, the actual bill that was enacted, but if you scroll down on this, you'll come to the top of license law. This is the act, and it says Chapter 57, real estate brokers, salespersons, and property manager, and it has the license law. Now, we're not going to make you suffer through staying on this website and looking for everything. You have a handout in front of you that has the license law printed. It's a little larger, hopefully with some titles and some trail markers as we go along. Then you can find what you need to know. That's where you find it. So let's go back. While you are doing, I'm going to stop sharing that and go back and find our PowerPoint so we can go forward. Okay, that is where, how, and what you do. Now that we've gone through the license law on the website, let's talk a little bit more about the trail. Okay, laws come from two sources. One source are statutes, the other's case law. We just visited a website. It showed a statute. Statutes are enacted by the legislature. Case law comes from decision of judges. If the statute's not clear, there's something in the law, then that's when you go to court. And judges decide things. That's case law. The license law is a statute. It's part of the code of laws, okay, as we call it, the code. The code is organized into laws, subject matter. There's 63 titles. Real estate law is title number 40, entitled Professions and Occupations. Then Chapter 57, as we said, as we saw, is real estate brokers, brokers in charge, salespersons, and property managers. Okay, that's our trail. We've looked at the trail, and as we've gone out and actually looked on the website, but there's also places here on the PowerPoints, but I'm going to skip through those because we've already done that. We've looked at those. So where is the map? Well, we know there's a trail. We need a map. The map is right where we've just been, South Carolina Code of Laws 40-57. That's where our map is. Okay. The code then is broken down into sections. Each article has sections. There are sections 5 to 810 that apply to real estate brokers, salespersons, and property managers. Okay. How is it organized into articles? Well, Article 1 is the general provision, okay? And that has sections 5 to 40. You then have Article 3, that's real estate brokers, brokers in charge, and salespersons. That has sections 310 to 380. Article 5, property managers, that has sections 510 to 520. And then you have Article 7, which is misconduct and redress. Those are sections 710 to 810. Okay. Hopefully we won't have to spend a whole lot of time in there, but we're going to read through that and go through that article carefully. Nothing else to somewhat ensure that you don't go into that. Well, then, how are we going to read this map? How do we go further into the map? Well, that's understanding how the law is written. it's broken down. We've already talked about it. It's broken down in articles, and we know that there are 4 of those. And we know that there are sections. Those are designated by capital letters, and they have headings on them. And the sections are further broken down into subsections. Okay? Subsections then are denoted, for example, 40-57-135A, duties of a broker in charge. Okay? We go further down into it, we have paragraphs. Paragraphs are designated by numbers. Example, 40-57-135A1 provides that the duties of a broker in charge is to establish and maintain a written office policy. Going even further, paragraphs can be broken down into subparagraphs, and they have lowercase levels. As I just popped up on the screen for you, it's just like an outline. Okay? You just go through it. So, how do we go through this? Let's do one together. Now that you know how it's broken down, that's half the battle. At least it won't seem so strange to you as we go through it. We'll know the structure, the license law, okay? We know how it's broken down. So let's practice. What does license law say about a transaction broker owing limited confidentiality to a client? What does license law say about a transaction broker owing limited confidentiality to a client? Well, you may still be saying, I have no idea how to find that. Let's do it together. First of all, which article is most applicable? We know that there are 4 of these articles right there. General provisions, real estate brokers, BICs and salesperson, property manager, misconduct and redress. So a transaction broker is a salesperson, right? So which one would you pick? I think it's Article 3. Transaction broker is a type of salesperson. Let's go with Article 3, real estate brokers, BICs, and salespersons. Now, we've gotten into Article 3. We know it's broken into sections. How do we know which section would be most applicable? Well, Article 3 has 8 sections. Each section has a heading. Headings are only for informational purposes. They're not infallible. It could be wrong, but generally in the law, all the information about one heading, one topic is in one heading. So let's look at these sections. We've broken them out. You have 310, qualifier for licensure, conditions for licensure, license requirements, license renewal, duties to clients and agency relationships, BIC's responsibility for teams, going forward, the disclosure of broker relationships, and termination of agency agreements. Those are our choices. So take a second, circle. Which of these do you think is most applicable to a transaction broker and what the transaction broker is doing? Okay. Just a pause. Well, confidentiality is a duty owed, and we're talking about confidentiality. So how about Section 340-57-350, duties to clients and agency relationships? Hey, well, we're still not there though, are we? So we've got our section, but which one, subsection, now moving forward, is going to get us to where we need to go? We've got that. Which subsection is most applicable? We can't. Maybe we're not right on topic on something, but we have to pick the one that is most applicable. Okay, so let's keep going further. Which subsection do we want to find? Well, section 350 has 12 subsections. Unfortunately, though, subsections don't have headings. You're going to have to read each one to get a general idea of the topic and that subsection and make your own headings. Okay, we're going to working on this together, so still in your materials. We're just on page 4, guys. We're going to still make it through the whole course, just on page 4 right now, though. But to illustrate here, you've got I've put for us maybe some possible headings. So let's look. A is permissible broker relationships. Okay. B is the office policy and having one is mandatory. C is seller agent. D is seller agent and competing properties. E is buyer agent. F is buyer's agent and competing properties. Keep going. G, you have disclosures of a material adverse fact. H, that the buyer inspection is not limited. I, you have dual agency. J, you have designated agency. This is a long one, isn't it? K is client and customer service in the same transaction. L, transaction broker and customer service. And M is a statute trumps case law in a private action. Now you may come up with totally different headings. Okay? This is not part of the law. This is just something that gives you a chance to look through and go and find, give me some idea of what is in that paragraph. Okay? This is not saying that you have to go, or I'm sorry, what's in this subsection. You don't have to pick those same titles as you go through. Which one do you think is closest to a transaction broker owing confidentiality? Well, I'm gonna go out on a limb and pick L, because transaction broker is part of the title of L. So I'm thinking that possibly that is the one that is closest to us. But we are still not there. We still do not have what we need to know. It seems that we're getting closer, but we're not there yet. So let's keep digging. Okay? We need to now know which paragraph is most applicable. Well, subsection L has 4 paragraphs. So let's look into those 4 paragraphs. Again, they don't have headings, so we're going to have to make up our headings again. So I went through, as I'm looking at this, and I'm saying, I agree, these headings that are provided here seem to provide the information we need. So which paragraph is most applicable to what we're doing? Well, paragraph 1 gives us what transaction brokerage is permissible. Paragraph 2 gives us the roles and duties of a transaction broker. Paragraph 3 gives us customer service as a single agent or transaction broker. Paragraph 4 is the licensee is offering services to customer. Okay. Well, I don't know. Doesn't seem to be to me. 1, 2. Well, we are looking at confidentiality, and transaction broker is certainly customer service. So possibly it could be under that. That's the one I would pick. Transaction broker is a customer service, so customer service as a single agent or a transaction broker. That's the one I would circle. Okay. Because it is another way of describing transaction brokers, but we still haven't hit pay dirt. Okay. So paragraph L3 has 7 subparagraphs. So now we need to figure out which subparagraph is most applicable. I'm going to go through, we can circle which one you think. Maybe you circle them as we read them. We've got honesty and fair dealing, accounting for all funds, using skill, care, and diligence in a transaction, disclosing material adverse facts, promptly presenting all offers and counteroffers, limited confidentiality. That's what we're looking for, isn't it? But let's look at G anyway. Additional duties that are entered into by separate agreement. We are looking for something that talks about limited confidentiality, and we have here now that paragraph F is about limited confidentiality. Success at last. So if we were to look in the law, which you could possibly take time to do that, flip over if you want to. You have all of licensing law there. If you look at 40-57-350 capital L to little f. That relates to a transaction broker owing limited confidentiality to a client. So do you see how you went when we started of saying I have no idea how I would possibly find something straight up in license law? No clue how to do that. It's not that difficult if you just take it step by step and go through. Now that we've found something, we need to read it and interpret it and know what does it say. Okay? What is it actually telling me? So there are some rules for doing that. And we need to go through those rules and actually understand what we're doing. Okay? First thing you need to understand is that you have to pay attention to all of the words. We are not reading a novel. We're not going through this quickly, skipping over a bunch of stuff, trying to figure out just general concepts. We want to be exact in this. So, in that sense, every word, all of the words, pay attention to all the words. And we're going to give special attention to certain words as we go through. But you need to know, like, all of the words are important as you go through. But here are some things that we'll go through. Shall, may, is there a difference? Yes. What's the difference? We're going to go. And, or, is there a difference? There is. What is the difference? Hold on a second. Unless and except and notwithstanding any other provisions of the law. Those are some of the big things that you're going to have to look at. Again, every word is important as we go through this. Meanings of the words are very important. In license law, that section is added, 40-57-30, gives you definitions. And those definitions of words, if you're reading license law, regardless of what you would like the word to mean or hope it means what the definition is in 40-57-30. Of course, every word is not defined. So if a word's not defined, how do you know what the definition is? That's what a dictionary is for. Okay, let's look at some examples. Shall versus may. Shall means you must do something. You have no discretion. May means you have permission to do it, but you don't have to do it. Look at the example we have. Okay? South Carolina Code Annotated 40-57-50 says the Commission may adopt an official seal and shall adopt rules and procedures. So Commission, have a seal, don't have a seal, law's not concerned. Legislature didn't care about that as much. But Commission, you shall adopt some rules and some regulations. Okay? And versus or. I said there was a difference. What is the difference? Well, and says you must do all the items on the list. Here's a list of items. You have to do them all. And we're going to look at South Carolina Code Annotated right there in your example, 40-57-135D1. Okay? You kind of know what that means now, don't you, as we've taken our little trip. Okay? There's a list of items. You must do them all. So in this example, the broker in charge, property manager in charge shall keep certain things for a minimum of 5 years. What do they need to keep? They must keep A, B, C, D, E, F, and G. All of them. All of them. What about or? Well, or you are also presented with a list of items. Okay? You must do one or more of the items on the list. Not required that you do all of them. In our example here, the site is here, but if you look in your materials, page 6 on your materials, a nice little chart here for you. It has the law written out for you. You don't have to flip back and find it. It just says in a dispute concerning the entitlement to or disposition of an earnest money deposit, and dispersing that, you can do it by 1, 2, 3, or 4. Okay? Obviously, you don't have to have all 4 of those. If I have a written agreement, why would I spend the money to go to court, get a judge to say how it's distributed, or do an interpleader action? So if you're trying to figure out how to disperse earnest money, statute says you've got 4 options, not 4 things you must do. Going forward, We talked about there's a difference between unless or except. Well, what is the difference between unless and except? Okay. Unless or except means you found an exception to the rule. There's a rule that controls everything. You've found an exception. Let's look at the site here for you again. Still on page 6. No need for you to flip back and try to find this. But it says the broker in charge or associated licensee shall continue to maintain this confidential information unless the party from whom the confidential information was obtained permits its disclosure by written agreement or disclosure is required by license law, required by law. Okay? So unless says, here we go, here's the rule. You've got to continue to maintain that confidential information. But there's an exception to that rule, and it gives you the exception. But you know, it's not difficult, somewhat like common sense. Problem is, for too many people, is they get psyched out. I'm not a lawyer. How do I read the law? Well, guess what? You are now going to know how to read the law. We've got one other little group of words here. Notwithstanding. If I come into notwithstanding, if you're around lawyers much, you will hear us roll off. Notwithstanding any other provision of this law, blah, 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 blah. It's like, it's a foreign language. Well, not a foreign language. It's just foreign too, and you get psyched out about it a little bit. What notwithstanding says is what follows notwithstanding applies regardless of any other provisions in the law. Doesn't matter what the statute says in a different section, a different paragraph, this applies. And your example is right here for you. See, South Carolina Code annotated, we got 350G1. Notwithstanding another provision of law, regardless what all of the rest of license law says, no cause of action may be brought against a licensee who truthfully disclosed to a buyer a known material fact. Okay. So despite confidentiality up here, despite that the person may want you to say, don't tell them that, don't say that, don't say that, despite all of that, you have to disclose a material adverse fact. All right, hopefully, you now have a much better understanding of how the law is written, where the trail is, where the map is, where all the trail markers are, how we interpret the trail markers. So it's time for us to move forward and give this a try and go through. We are now going to take a break, and then we will continue our walk through the law. All right, next we want to be in I-5, an offer rejected without a counter. Again, on page 20, an offer rejected without a counter. You must use an offer rejection form. Okay? It's produced by the Real Estate Commission. You must use the one that they produce. It has to be signed by the licensee, and it confirms presentation of an offer, and it must be given to the offeror by the licensee. Okay, this is again to ensure that all offers are presented. Okay. Told you there had to be a mandated form. Here is that mandated form. The real estate offer rejection form. You see the LLR logo in the left corner? That means this is the one you need to use. Oddly enough, I bet before this class you may have skipped over that part that says section 50-57-135I5, thinking, well, I don't care what that means. Well, now you know what it means. You know where you can find the law regarding this form. Okay. As you look through it, you'll see it has a place for the written offer, identify the property location, enough so the offeror will know that the licensee has presented the offer on this property. It's signed by the broker or licensee, not by the member of the public, because the Real Estate Commission has no authority over a member of the public. It must use this form. All right, before moving on to trust accounting, let's go down, and we're on page 21 of your outline. Let's take a pause by our trail marker campfire there, K. An unlicensed employee may not. It's very important to know these are things an unlicensed employee may not do. They may not negotiate or explain a contract or some other real estate document. Okay. If there's a predetermined rental price or predetermined terms, they can give that information out, but they can't vary or deviate from what's predetermined. They may have an rental application in front of them, but they can't approve that rental application or a lease. They can't negotiate, settle the terms and conditions of a lease. Okay? They cannot hold themselves or indicate to the public that they have any managerial authority, that they're in any position of authority. Can't host an open house. They can't say, well, they'll just go out there as long as they don't vary from terms. Nope, can't host an open house. Can't manage an on-site sales office or leasing office. Can't be the manager. Okay? Can't show real property. Now, there's an exception to this, and that's a vacant unit in a multifamily housing building. Okay? That is an exception. They can't answer questions regarding listings or title or financing or closing issues, etc., except for giving any public information. Okay? They cannot be paid solely on the basis of their real estate activity. So they can't be paid on their production, in other words. Can't negotiate or agree to split any commissions, management fees, referral fees, etc. And basically, they just can't do anything that requires a real estate license. Okay? Now, let's stop for just a very short time. We don't want to spend a whole lot of time on this, but let's stop for a very short time and hit the highlights of what's mostly applicable to the associated licensee with trust accounting. First, when do trust funds have to be delivered to the BIC? Okay? Within 1 business day, no later than the following business day. When does that BIC have to deposit those trusted funds? If it's a cash or certified check, within 48 hours of receiving it. If it's a company or a personal check, within 48 hours of acceptance of the offer. That would be acceptance of the offer. Okay. How about dispersing those funds? Is there some kind of thing that's a safe harbor that the person, the BIC who's responsible for this knows that, hey, this is always going to be okay? There are. And that's in B2. See your campfire there? If they can disperse the funds properly upon the rejection of an offer, the withdrawal of an offer, or the closing of the transaction. Okay? Those are the times when the BIC knows they can disperse those funds and still be okay. Before we move forward to the next break and then the next article, look on page 25 of your outline, applicability of this chapter. Just very quickly, these people do not have to have a real estate license. One is an owner selling, leasing, or renting his own property. Now, the key to that is he has to be selling, renting, or leasing his interest, the same interest he has in the property as what he is selling, leasing, or renting. An attorney representing a client doesn't have to have a real estate license. State or federal government acting within the scope of their official duties. A forester selling land if the sale is merely incidental to selling all the timber. What is the real money is selling all the timber. Or a court appointed, is the way some people pronounce that word, receivers and trustees. Those are the ones that don't have to have a license. Time to stop, not only for an important trail maker, but for our next scheduled break. Welcome back. I hope you had a great break. We're going to move along now to Article 3. And before we look at the independent elements in it, let's look at the sections. Let's look at an overview. We're going to go over some qualifications for licensure. What must you do to have a license? License renewal. You have a license and you want to have it renewed. What do you need to do? Well, as far as continuing education, you have to take 10 hours total, whether you're a broker, a salesperson, or a BIC. Just the composition of those 10 hours is a little different. If you're a broker or salesperson, you have to have 4 core hours, which is what you're satisfying today, and 6 electives, so 6 other things that you would like to take. If you're a BIC, you have to also have this core class, but you have to have the dedicated mandatory BIC class, and then 2 electives. We'll then move on and we'll look at types of brokered relationships and the office policy. What must be in the office policy? We talked about earlier about the office policy has to have certain things. You have to have one. Well, this is what you have to have in that office policy. Then we're going to do a little bit on duties to seller and buyer clients. And moving along, we're going to talk about dual and designated agency. What's the difference? explain them. Duties to customers and duties to clients. All about teams. What do teams have to do? We looked at the definition of teams earlier, but what about teams? What has to happen for the team to operate properly? Disclosure of broker relationships and terminating agency relationships. What do you have to do to terminate an agency relationship? All right, so for license renewal, moving on, it's in 40-57-350, and it has what the requirements of license renewal. And on page 28, so every 2 years, everyone has to renew their license, every 2 years. Now you have to submit a criminal background check on every third renewal. Then complete a total, as we just said, 10 hours of continuing education. Everyone takes a core class. The BIC has to take the BIC class. Now, there are some exemptions from continuing education. One is a salesperson who completes the post-licensing or broker course in the 2 years of the renewal. They've already had more than the 10 hours. Then, if your license is on inactive status, you don't take the continuing education. If you're a non-resident broker, so you live in another state and you've satisfied your continuing education requirements in that state, you don't have to take the South Carolina classes. Or an exception for someone who's been licensed for at least 25 years, you get a partial waiver. You only have to take the core class or the core and the BIC if you're a BIC. Basically, you just don't have any electives. You waive any electives that may be there. So, guess I need to catch up on my slides a little bit. Exemptions, 25 years experience, exempt from the electives only. Now, something to know, you think, well, I'll just go ahead and take a lot of courses this year. Well, that's going to be good for your career. It's going to help you be a much better associated licensee, but you're not going to get to carry those forward. So no carry forward. If you fail to meet the requirements, okay, if you do not get your continuing education requirements, your license will go on inactive status. And remember, we talked about the consequences of that. If your license goes on inactive status and you don't have a valid active license, you can't receive a commission. And providers, anyone teaching you a class, the providers have to electronically transmit the class that you took, that you've taken that class, directly to the Real Estate Commission. Directly to the Real Estate Commission. Piece 29, important trail markers. As a question, what are the requirements for license renewal? And you see there's a place for the BIC and for the salesperson. A little bit different. Okay, now moving along, as we go forward, we said we would talk about the types of brokerage relationships. What types of broker relationships are authorized? What can you do? Okay, those are in 40-57-350A. That's where we find those. Okay, so if you'll look at 40-57-350A on page 29 of your handout, you'll see the very part that a firm owes the client these type of duties. These are the duties to just a client. Before we get into what the types of relationships, the first part of A, it has in here these duties that the firm owes the client. One is obedience, one is loyalty, disclosure, confidentiality, accounting, reasonable care and diligence. Now, if you look straight at your statute, as I was reading those off, you'll see that they're not exactly in that same order. And the reason they're not in that order is they're rearranged to spell old car. So you can remember your statutory duties to a client, old car: obedience, loyalty, disclosure, confidentiality, accounting, reasonable care, and diligence. That's just in the first of that paragraph. Then we get into the actual types of permissible brokerage relationships. Of course, one is your seller agency. You can be an agent of the seller. You can be an agent of the buyer. You can be a disclosed dual agent, designated agent, or a transaction broker, practice transaction brokerage. Okay? So we have the agency and then the transaction broker, the non-agency. We've been saying associated licensee, and that was a new definition in the remake of the law in 2017 that came out January 1st, 2017. Associated licensee because you're not always going to be an agent, okay? It used to be real estate agent. You're not always going to be an agent anymore. You can just be a transaction broker, take a client all the way to closing. Now, office policy. What has to be in the office policy? Page 30, 350B, 40-57-350B has what has to be, what must be. If you read the actual language, written office policy must include. What must it include? The types of brokerage relationships allowed. Well, we just went over the types that are permissible, but what does your particular brokerage firm allow? The one that where your license is, what does your BIC allow? Okay. Cooperation and compensation to a buyer agent and to a transaction broker. Okay. Does the firm cooperate with both? Duties to customers. What duties are owed to the customer? What duties are owed to the clients? Okay. All this has to be spelled out. Okay. When and how brokerage relationships are disclosed. Okay. How is that going to be disclosed? When and how dual and designated agency is disclosed. And last, fair housing policy. What is the firm's fair housing policy? Okay, also in your office policy is what brokerage, what the brokerage will allow in relationship. In their office policy, they have to say what will they allow in regard to teams. Okay. Needs to address various things of a team. How a team is formed. How members of the team are paid. How the team is supervised. Remember that very short definition we had of a team? We know who has to supervise. The BIC. The BIC has to supervise all the members of the team. Another part of what can be in the office policy is, will the brokerage allow limited function referral office? Limited function referral office is that the agent or the associated licensee, may refer, paid for referrals, but can't do any selling or listing. So again, page 30 of your document, of your handout, look there, important trail markers. What types of allowable brokerage relationship? What are the types of those relationships? Okay. And limited referral, no sales or property managed, referral placement only. Okay, let's move on and talk about the duties to seller and buyer clients. What are the duties to seller and buyer clients? We're going to go through beginning on page 30 of your outline, and we're going to stop at several of these places. We're going to stop at C. C starts by saying, what are the duties a seller's agent? Now we're talking about a seller's agent. We're going to go through the various types of brokerage relationships and what are the duties of. What does a seller's agent have to do? And you say, why do you say have to? Because it says shall. Well, in an overall sense, just as a stand back and look at the whole layout, there's two things. One, perform the terms of any listing agreement, and two, promote the interest of the seller. That's a little too much of a summary of the actual duties. So the code, license law, tells you how you promote the interest of the seller. What are some of those things that you must do to promote the interest of the seller. Okay. Well, one is seeking a sale at the price and on the terms acceptable to seller. What does the seller want to see? What do they want to, how much do they want to receive? What terms are important to them? You have to present all written offers and counteroffers in a timely manner. Don't lose me, I'm on page 31. Okay, present all of those in a timely manner. Disclose all material adverse facts. We're not left holding the bag wondering what a material adverse fact is. We have a definition of that in 4057-30. And by the way, all those definitions are in alphabetical order, which is kind of nice when you're searching for one. Okay. Advise the seller to obtain expert advice when needed. If the seller is asking questions, now you kind of are used to not giving expert legal advice possibly when it comes to law. Not only in law, any expert legal advice, don't get outside your expertise. Okay? As we say, don't get above your pay grade. This is not something you need to know as an associated licensee. Be very, very careful about giving any advice. Okay? And accounting for all money and property in a timely manner. Okay, moving along, as an associated licensee, you have a duty to your seller client to exercise the agency duties with reasonable skill and care. That's reasonable skill and care. And a lot of that's outlined for you. We went over it just a little while earlier in the old CAR, the duties there that you must do. Okay. Comply with license law. Boy, that's what, 1, 2, 3, 4, 5 words, but boy, are those act words. Comply with license law. You must comply with all license law. Comply with all fair housing and civil rights laws. Okay. It's important that you know what the fair housing rules are and how that affects you in your day-to-day interactions with all consumers. Okay. But those fair housing laws, lots to know there. So it's in your office policy. What are the rules there? Make sure you read through that and understand. If you have a question, ask. And civil rights laws. What are the civil rights laws that you must comply with? Okay. And preserving confidential information. You must preserve confidential information unless the seller grants written consent to disclose the information, or license law requires disclosure. Possibly you know a material adverse fact. Really doesn't matter that the seller doesn't want you to disclose a material adverse fact. The law requires you to disclose that. Hopefully that won't become an issue for you. If you can disclose confidential information, if there's some accusation of wrongful conduct on your part, or information becomes public from another source. If it becomes public from another source, it's obviously not confidential anymore. Now, let's look at what a buyer's agent has to do. What does the buyer's agent have to do? Well, again, we can do a high view of this and look down and see two main things: perform the terms of the buyer agency agreement and promote the interests of the buyer. Very much like the seller, it gives us a way that we know we're promoting the interest of the buyer. One is seek a property on the price and the terms acceptable to the buyer. The buyer tells you what they want, tells you how much you want to pay, tells you what the terms are, and you're going to work for that buyer. You're the buyer's agent, which means you're putting that person's interest ahead of yours. You're acting as their agent. Well, you want to make sure that you are seeking what they want. To protect them, you want to present all written offers and counteroffers in a timely manner. You want to disclose all material adverse facts. Discuss what is a material adverse fact. You must disclose those. That is your statutory duty. License law requires it. Moving along to page 32, you want to advise the buyer to obtain expert advice when needed. Okay? Anything that they start asking a question, well, what about this? What about this? What about this? If it's outside your expertise, do not hesitate to recommend that they obtain expert legal advice. It's in their best interest and it protects you. So don't hesitate to do that. Of course, accounting for all money and property in a timely way. You have someone else's money, someone else's property, you have to account for that. Then exercise the agency duties with reasonable skill and care. You're expected to be able to operate and perform on the level of a competent agent with reasonable skill and care. There are those 5 words again. Comply with all licensed law. You must comply with all licensed law. You also, as a buyer's agent, must comply with all fair housing and civil rights laws. Requires. You still have a duty to do that. And very much mirroring the seller agent duties, preserve confidential information unless the buyer grants written consent to disclose the information. The law requires its disclosure, or if someone's accused you of some wrongdoing and you must release information. And then finally, if the information becomes public from another source. Moving forward to another duty, let's look at F. F addresses the situation where you have 2 competing buyer clients. Talk about dual agent designated agency later. When you have a buyer client, buyer seller, a seller client and a buyer client, this is you have 2 buyer clients and they both want to are interested in one possibly offer on the same property. They're ready. Okay, we need to protect them. Okay, we don't want them to feel like that you are giving one information of the other. So if you have 2 buyer clients and you're giving they're competing for the same property, then you must give each written notice that neither will receive the confidential information of the other. Now, this is something that's required by law. However, the law did not require that the Real Estate Commission promulgate a form or create a form for this. If you are a realtor, if you are a member of the South Carolina Association of Realtors, you can use the form that you're looking at. This is a multiple buyers disclosure. Now, this form is copyrighted by the South Carolina Association of Realtors, and only members have access to this form and all other forms. We put it up here as an example and to reiterate the fact that you must have a disclosure signed once these 2 buyer clients begin competing for the same property. Okay. Again, this form is a South Carolina Association of Real Estate form. It's used here with permission, but it's only available to members of the South Carolina Association of Realtors. That is a form you can use. Okay. Now, let's move forward. Now, I tell you what, before we move forward, look on page 33, and you'll see here important trailed marker agent duties. Okay. Spend some time summarizing the duties of agents. That's what that little stop a second, catch our breath before we move down the trail a little further. But as we move down the trail a little further, we'll look at about dual and designated agency. Okay, what are they? What's the difference? What are their requirements? Well, again, as we've been doing, we don't make this up. We go to license law. And license law in 40-57-350 I through J, okay, I through J, addresses the issues of dual agency, designated agencies, and the requirements for both. Okay. Looking in dual agency first, this is in I-1. I'm on page 33 of your outline. I-1, dual agency. A licensee can act as a dual agent only with the prior informed and written consent of all parties. When you're acting as a dual agent, you have 2 masters. You have 2 clients in this situation, a buyer client and a seller client. before you may proceed to represent both of them as an agent, you must have their prior informed and written consent. Well, how do you know for sure you have their consent? Well, it's presumed, the consent is presumed if they sign a dual agency agreement, but not a blank one, a properly completed dual agency agreement. Now, this isn't something you say, sign here and we'll fill it out later. You should never do that, but in this case, particularly dangerous. You must use the dual agency agreement that's written by the commission. Okay? Commission wrote one. You must, under the law, you'll look at the license law, right there, it says you must use this form. Again, I showed you on the website where you find forms, okay, how you can go over and find them. These forms are right there for your use. It has the LLR logo in the corner. This is a form that must be used under the law for a dual agency agreement. This dual agency agreement has a lot of information in it that the client needs to read and understand. It also has a place there, as you can see, for things, blanks to be filled in. And once these blanks are filled in, we've already talked about, we'll talk about some more, that part of the office policy is how will your firm require you to explain dual agency and designated agency. But once the client has understood this, gone through it and understood it and signed it, and that is presumed that they have consented to you proceeding as a dual agent. Now, when do they sign? The buyer must sign before writing an offer. The seller signs before signing that offer to make it a sales contract. That's your timing. Okay? Now, the reason we're stopping, speaking a little more slowly, taking a little rest here, is because the two clients must understand that their interest could be adverse. Okay? The seller wants the highest price, the buyer wants the lowest price. You know, or at the very least, they both want a fair price. But because their interest, not only over price, but other things could be adverse, then your agency duties are going to be limited. You can't talk about all the things that the buyer has told you. You can't talk about all the things that the seller has told you. Okay? That's dual agency. We also have designated agency. Okay? Designated agency exists. You still have a buyer client, you still have a seller client. But buyer client and the seller client just do not feel comfortable with you representing both of them. So the BIC designates one associated licensee to represent the buyer client and one associated licensee to represent the seller client. The BIC and all other associated licensees in that firm are dual agents. Okay. Now again, the buyer and the broker must sign a designated agency agreement. Okay. And you can imagine, it's similar to the dual agency agreement, they must sign the designated agency agreement that was written by LLR, or the Real Estate Commission. This is the only form they can use, okay, that you can use and that they can sign. It must be this form. I'm on page 34 of your outline if you want to read the actual code that says it has to be written by the Real Estate Commission. Here's your form. Again, you find it on your website, on the LLR website, Real Estate Commission section of the website that gives you all the forms. Same place went to licensing law, but you'll hit forms instead of real estate law. Okay? Now, this form, similar to the other one, must be signed by the buyer before writing an offer and by the seller before signing the contract. That's dual and designated agency. Okay? It's very, very important that these issues be explained to the clients. This could get very sticky if you are limiting. They're starting off thinking, although you've explained to them up front when you did your listing agreement or your buyer agency agreement, you explained this and that, and those documents most likely should have gone through all of this. Your brokerage relationship form talks about dual agency. They should understand this, but sometimes what we think we understand initially, when it's kind of more in the abstract to them, becomes very, very real, and they start to realize, wait a minute, your duties are limited to me. It's not the same thing. So take some time, stop, page 35 of your outlines, very, very important trail markers. Make sure you understand the difference between dual and designated agency, what the difference is, how you use each, when those disclosures have to be done, and then as we've said and shown the forms, that it must be done on these two forms, mandated, no exceptions, no exceptions. All right, let's get a little lighten up a little bit here. Let's talk about the duties to customers and clients. Okay, and the duties to customer and clients are found in 40-57-350. K, section K to section M. And for you, that's on page 35 of your outline. So if you'll go here, we're going to stop at some places. We're going to stop first, section K. A licensee who represents one party may perform ministerial acts for a customer, such as writing and conveying offers. Remember, we had the definition for ministerial duties. This is something that you're not exercising your discretion and your judgment. Okay, you're representing a customer. Moving ahead, customer service. What are the basic duties of customer service? Okay. Honesty and fairness. We're looking on page 35, okay, page 35 of your outline. L. Okay, this is customer service, is basically the same as transaction broker. Okay? And a transaction broker can be a single agent of one party and giving the other party customer service. Or the transaction broker can facilitate the transaction without representing either party. And we have here the information that they can facilitate, or they can represent both parties. Then they would be the agents, dual agent designator, or they can represent agent of one, customer in the other. So we're talking about transaction brokers. They must disclose they will offer the following, and the they in that sentence are the people that are operating as a transaction broker. This is general. Honesty and fair dealing, okay, accounting for all funds, using skill, care, and diligence in the transaction, disclosing material adverse facts, promptly presenting all written offers and counteroffers, okay, and limited confidentiality. Okay. Limited confidentiality is defined, and now we're on page 36 okay, of your outline. The buyer's motivation to buy, or the buyer's willingness to make a higher offer. It's a transaction broker. You cannot reveal that. You owe the duty of limited confidentiality. You cannot, if you're representing the seller as a transaction broker, the seller's your customer. You cannot discuss the seller's motivation to sell or the seller's willingness to accept a lower offer. You cannot discuss that a buyer or seller will agree to financing terms other than the ones offered. And you cannot disclose any information that the party asks you to remain confidential. Now, services that may be offered, these are things that may be offered to a customer, are identified and showing property. Make sense? You can identify and show property. You can provide real estate statistics and information on a property. Okay? Just pure information. I'm passing along information. You, of course, can provide pre-printed real estate forms. You can act as a scribe in the preparation of those forms. They can tell you what they would like you to fill in those forms, and you can fill those in. You can provide a list of professionals, such as inspectors, lenders, attorneys, surveyors, etc. You can provide those lists. You can identify schools in the area, shopping facilities in the area, places of worship. That's fine. You may do all of that. Okay. What services shall you give a customer? Mandatory that you give the customer. Okay. You must timely present all written offers. You must timely account for all money and property. You must provide a meaningful explanation of any broker relationships. Talked about the possible broker relationship, broker relationships. Provide an explanation of the scope of services you're providing. Be fair and honest and provide accurate information. You can't lie to people. Any information you give us has to be accurate. And keep information confidential if the customer requests it. And also disclose known material facts regarding the transaction or the property. All of those are listed on page 36 of your handout. Now, I jumped the gun on the slide. This is a nice slide to kind of summarize, as some people pronounce that word, some of your basic duties. Customer service, honesty and fairness, presentation of offers, disclosure of material facts, limited confidentiality, performing ministerial acts. Those are the things that are basic duties, kind of summarizing all of those other duties we went through. What customer service isn't is giving advice, counsel, advocacy, or exercising of professional judgment. No, it is not customer service. Okay? You give your advice, you give your counsel, you're an agent for, an advocate for, and exercise your professional judgment to a client, not to someone who is a customer. All right, moving along. If you go to page 37, said these are the things customer service doesn't get. On page 37 of your outline, you have an important trail marker. What does a customer receive? What services does a customer receive? What services does a client receive? Time for you to kind of explain and understand the duties between the two. The slide hint should be a lot of help in that. All right, let's move from customer service to teams. All about teams. Teams are in 40-57-60. We're on page 37 of your outline, 37 or your handout. This gives information about teams. And there's some team rules. You notice our graphic down here, together everyone achieves more. The most important word in that is together. That's why we have so many rules about teams, because we have associated licensees working together. And we want to make sure as they work together that the public is properly protected. One rule is the BIC must supervise. The BIC must supervise all of the team members and the team. Okay? All the individual members are supervised by the BIC, not by a team leader. Okay? Dual agency only when there are two clients within the team. If there are two clients within the team, associated licensees are different, but two clients within the whole team, dual agency. Okay? You're thinking, what? Why? Well, because together in team. The team members are working together. Work from a commission-approved office. When we looked at our definition, that was part of it. They work from an office. You must work from the office. It's approved by the commission. Advertise only under the brokerage name. The firm name must be displayed in conspicuous way in all advertising. Nothing about the team may apply that it's implied that it's separate, as some type of separate entity from the firm. And part of that rule is to be very careful with the team name. It cannot contain the words real estate, realty, realtors, similar terms that might make a member of the public think somehow that the team is separate from the firm. It cannot be. It is a part of the firm. That is why the rules say the firm name must be displayed prominently and conspicuously, always making sure that the public knows that the team is part of a firm. And see the part right down there at the bottom of that page 37? The commission may approve regulations about more to come with teams. In English, that means that the real estate commission is going to if they want to, make more rules, more regulations, anything the restrictions that flesh out the law that the commission feels necessary to protect the public. Okay? Then there are important trail markers section here. I'm on page 38. Actually, the regulations are on the top of page 38 there. I was indicating they were on 37. They're top page 38. That some of the things that are already there regarding teams and team activities. Time to stop and think. Okay. All right. That brings us to the next scheduled break. I'll see you back shortly. Welcome back. I hope you enjoyed your break. Now I'm going to talk about disclosure of broker relationships. Disclosure of broker relationships. Okay. This is on page 38 of your outline. We're going to look in section 40-57-370. 40-57-370. It gives us the information that must be in or must be complied with for disclosure of broker relationships. Every potential buyer or seller is presumed to be a customer. That is, walking in the door, they're presumed to be a customer. At the first practical opportunity after some substantive contact, a term defined in 40-57-30, the licensee shall provide this information. A meaningful explanation of broker relationships in real estate transactions. We went through those that are permissible, seller, buyer, dual designated transaction broker. This must be explained at first practical opportunity after substantive contact to any potential buyer or seller. Okay. Then the associated licensee must explain which of those brokerage relationships are offered by his or her firm, an explanation of the client and the customer service to where the potential buyer or seller can understand, and then the mandated disclosure of broker relationships form. Okay, here it is for you. South Carolina Disclosure of Real Estate Brokerage Relationships, LLR, logo right there in the upper left-hand corner for you. That is the form that you must use, mandated. Okay, it's a 2-page form, front and back. Shows you you're a customer. Flip it over. It talks about you being a client. Talks about dual agency, designated, etc. Okay, must use this form. Okay. Now, about brokerage relationships, okay, if you're using some type of electronic disclosure, in the electronic disclosure, then disclosure, if your contact with a person is electronic, your disclosure can be electronic. Also, there's no presumption of an agency relationship. Someone may say, well, I assumed you were my agent. Agency has to be established through a written agreement. It cannot be established by orally, by just agreeing that someone's your agent, or by any type of implication. Okay? That is not permissible. Okay? Payment, someone paying you, does not establish or determine an agency relationship. Okay? That's not how you create. You must have a form signed to establish agency relationship. Now, there's a place, important trail marker, page 39. When and how does disclosure of broker relationships take place? We know that you've gone through the form. We know your office policy has to talk about this, but let's take a little while and fill that in and determine, see if we understand. Okay. Now, transaction brokerage is the default relationship. Okay. That is the default relationship until a brokerage agreement is signed with the customer, consumer, customer, consumer. Okay. You're our transaction broker. Okay. You say, well, what type of broker agreement are we talking about? Listing agreement, buyer agency agreement. Okay. It has to be something established in writing before we can do that. Okay. Now, moving on. This is your transaction broker agreement. This does not establish an agency relationship. This makes clear that the associated licensee, the firm, contract between the firm, will assist the customer. And here are the terms. This form is put out by the licensing, the LLR or the Real Estate Commission. However, it is not mandatory. This particular form is not mandatory. So, moving along, how we got in this agency relationship, how do we get out of an agency relationship? We know that we have to have a written agreement, we can have a listing agreement, we can have a buyer agency agreement. We know that transaction broker is our default position, but giving customer service default position. But once we cross that line and decide that we are now someone's agent by a written agreement and they fully understand you're an agent, at some point, the relationship needs to end. Ever been in a relationship like that? This thing's got, yeah, sorry, I digress. But how do we terminate an agency relationship? Well, we look at the rules. We look at the license law. That's our looking at our map. 40-57-380, you'll find that on page 40. Okay, 40 of your handout, page 40. Okay. And it says, after termination, expiration, completion, performance, or closing of a real estate transaction, the licensee doesn't owe any further client duties. Okay. So how is that terminated? Where do we find it? Right there. Termination, it expires, agency agreement expires. You completed whatever the agreement said you would do. You performed the agreement fully, or you close the real estate transaction. All of those things are known as terminating the agency relationship. Now, you owe no further duties. There's that little word, except, okay? So the rule is no further duties. We've got except, we've got an exception to the rule. Accounting for all money and property. You know, those things, don't you wish you had $1 for every time you remember we said accounting for all money and property? It's throughout license law. It's very, very important that you make sure when you have someone else's money, someone else's property, you account for it properly. Okay? You'd still have to keep some information confidential. During the course of this representation of your engagement with them, there were things either that the client said by request or some type instructions, I want this to stay confidential. That survives the termination of the agency agreement, unless the client gives written permission and say, yep, I said that, I'll put it in writing, keep it confidential. I'm now releasing you from that commitment. The law requires some disclosure. Disclosure is necessary to defend against some accusation of wrongdoing. Someone's accusing you of doing something that is wrong, and so you have this provision that you can defend yourself, or the information becomes public from another source. Remember, those are basically the rules we see each time we start talking about confidential information. Okay, page 40 of your handout, important trail markers. How are agency relationships terminated? How are they terminated? Okay. We just went through that. I would just hint, look at the top of the page. Okay. All right, let's move on. Let's talk about property managers. Okay. I'm not going to spend long talking about property managers, but this is the whole Article 5. Remember, you can't hold a property management license and your salesperson or broker in charge. I'm sorry, that you don't need a property manager license to be the broker in charge, but you can't hold a broker in charge and a property manager in charge license at the same time. Not sure why you'd want to. Okay, looking at page 41 of your outline, we're going to look at some, in this section, look at the bold underlined text for you. There's underlined text in your outline on page 41, continuing on to page 42. The main sections are 510, 520, or these sections are 510 and 520 for property management, and in that you'll find the licensing requirements. If you'll look, you'll see the underlined text. It has to be eligible for license. Read through that if you want to see about getting a property management license. You have to have an examination, okay, for licensure. You got to provide proof, the commission, of having met some educational requirements. Those are listed there for you. Okay. Again, going to page 42, an individual may not be licensed in more than one classification at a time. You have to submit a criminal background check, and then it's not bold for you there. Not underlined for you there, but 520 gives you some management of residential multi-unit locations. If you're interested in doing management of multiple locations, and then allowable duties, what you can do and what you can't do. Okay. Again, this isn't a property management continuing education class, but we told you we were going to walk through the law, so we're going to put our foot in all articles and most every provision in this. Okay. Article 7, very important for you to understand this. Hopefully not something that you are going to need to too much and understand too much of. In Article 7, an overview of Article 7, we'll find our grounds for discipline, information for investigations. What about revocation of your license? Actions and education. Cost and collections, how we collect if there's cost. And confidentiality of investigations. What happens if you fail to renew your license? You already know that answer. We talked about it. It becomes inactive, and at that point, no commissions for you. And information about civil actions under the license law. Someone can bring a civil action. They can sue you in court for your violation of license law. And information about service of process. That is all of Article 7. Okay. If you will look on page 43 of your outline, we're going to stop at some of these little campfires, talk about grounds for discipline. What are the grounds for discipline? Okay, those are found in 40-57 510A. 510A, that's where these grounds are found. One is if you make a misrepresentation on an application, your substantial misrepresentation on your license application. That can be a ground for discipline. 2, if you make a substantial misrepresentation about a transaction. There's a real estate transaction. You cannot make a substantial misrepresentation and expect not to be brought up on charges for that. false promises. Okay? You cannot make some type of promise to try to get somebody to influence, to persuade them, to induce them, to encourage them in some way to get them to take some action. Okay? Again, we're on page 43. Let's stop at 5. Bad faith and dishonesty. If you demonstrate bad faith, if you demonstrate dishonesty, if you demonstrate untrustworthiness, or you demonstrate incompetency, any of those things, then that could be grounds for discipline. That's when you'll have a complaint filed against you and an investigation, and the games begin. You may not guarantee future profits from the resale of real estate. Okay? Don't sell someone a house or a property, any type of real estate, and say, boy, this is one hot area, you're going to double your money in 2 years, or double your money in a year, or I understand you might be moving, but this area is so hot, you surely can sell this for a profit if you do get transferred. Okay? Don't make statements like that. Okay? Conviction of certain crimes. There are certain crimes for which a conviction can cause you to be disciplined for your real estate. Think about this. You know, a lot of the law, I won't say all, I'm a lawyer, I won't say all, but a lot of the law is just common sense and logic. Okay? We really want someone holding a real estate license that's going to be taking people possibly alone. Safety rules wouldn't dictate that, but meeting someone at a house, going into a house, going into a fully furnished house, or being in an area alone with someone and not have the public know that person is a person who has not been either pled guilty, convicted, pled guilty, or no contest to these type of things. Okay? Federal and state fair housing rules, laws. We don't want people violating those laws. We don't want people who have forged something or embezzled, or a breach of trust is when you have property entrusted to you and you kind of abscond with it. You know, you do something with it that you shouldn't do with it. Larceny. We know on here, the word's not used in here, but we already know the definition that we saw in the definition section of conversion. Okay? You don't want somebody to obtain money or property under false pretenses. Extortion. We don't want someone to extort money from a member of the public. Fraud or conspiracy to defraud. We don't want you to commit fraud, or we don't want you to conspire with someone to defraud someone. Okay? Then we have a list of felonies here. Sex-related felonies, drug-related felonies, real estate-related felonies, financial felonies, or violent felonies. We don't want someone committing any of those felonies and still have a real estate license and represent themselves or hold themselves out as representing as an agent or a customer, someone being an agent or a customer. We just want to protect the public. Okay? Moving along, lots of grounds for disciplines. Again, I'm not hitting all of them, but here we go. Still on 710A, page 44 of your outline. Okay? You have to make sure that within a reasonable time, you account and turn in all trust funds. Okay? Don't pay commissions to an unlicensed individual or any other compensation to an unlicensed individual. You can't offer to pay a referral fee or a finder's fee to an unlicensed person who is not a party to the transaction. So you cannot agree to pay someone for doing actions, real estate actions, that we know are a violation of license law. Makes sense when you put it that way, doesn't it? Fail to disclose the party for whom you're acting as an agent. Okay, this is undisclosed agency. Receiving compensation for more than one party. You cannot have compensation, things you're earning, funds that aren't disclosed to everyone. Okay. 16, we've talked about dual agency. Again, on page 44, we talked about dual agency. You can't represent more than one party in the real estate transaction without the written knowledge and consent of all parties. That's your dual agency. Okay? You can't do that. Remember, if you're a dual agent, you must have that form signed that the real estate commission I'll put out for you. Okay? You cannot be an undisclosed principal in a real estate transaction. Then moving along, still over page 44, but still going, you cannot fail to disclose the escrow agent. What is the escrow agent doing? The escrow agent is holding someone else's money. We want to make sure you disclose who that person is. Moving to the next fire, 20. Failure to disclose a known material fact concerning a real estate transaction. If you must disclose those material adverse facts. 23, you can't give false information, okay, to an investigator. We're not going to let you lie to the investigator. Okay. Then moving along, 24, another licensee has an agency relationship. Okay. You can't jump in the middle of that relationship. Okay. You can't do anything inconsistent with another licensee's relationship with their clients. Okay. You cannot interfere with that. All right. Now, moving. Ooh. Okay. Up, number 26. Now we're on page 45. We're on page 45. Okay. Can't fail to submit all offers and counteroffers. All offers and counteroffers. You must submit them all. 27. Commission is serious. You must provide your current contact information to the commission. Okay. You may think, why does that matter? Well, it matters for several reasons. Okay? You have a license with that commission. They need to know how to get in touch with you. Okay? They need to know that. It also, if I, as a member of the public, have a complaint against you, I need to be able to go on to Real Estate Commission website, look you up under that little tab that says licensee lookup, and find correct information about you. Okay? I need to know that you're doing business under the name that is on that license. That's why I need the correct name. I need to know that if I want to find you or file a complaint against you, that I can identify where you are. Maybe that's how I'm going to even know or determine who you are, so I can file the complaint. You say, well, I don't want anybody to file a complaint. Well, you could be disciplined for not keeping that current information current, just like you could for other complaints filed against you. So, I'm not telling you how to do your business, but I'm telling you what the law says of how you do your business. Okay. Delaying and closing for a commission. If you allow or create an unreasonable delay in or termination of a closing due solely to your commission dispute, then you're in trouble. Okay? That's grounds for discipline by the Real Estate Commission. Okay? We are not going to let people that hold a real estate license representing others, either as a client or as a customer, delay, create some unreasonable delay, or even have a closing fall apart because you can't get along with your fellow licensee over a commission. Careful. I got a place here, another important marker. Select one of the 29 issues above and explain why it's an example of misconduct. Spend some time on this. I encourage you, spend some time. Don't just say, okay, there are all of those in there. We've hit the highlights. It very well might be good for you to not only hit these highlights, but think of the other. I would read through every single one of them. I would not try to memorize them to say, okay, what did it say about this? But understand the theory behind each one. Why does license law care if you do these things? I mean, memorizing a list of them is much more difficult, just like what we just talked about, delaying a commission for a closing. The public's not going to be hurt. For each of these, think in your mind, how is the public hurt if I do these things? You have a privilege to have a license. You need to go over these things and think about them before you get into a discipline action. Lose your license. Okay, bonus question. Why do we want to notify the BIC of all the charges. 40-57-710B, which is on page 45 of your handout, says that if after an investigation charges of violation are brought against the licensee, the broker in charge or property manager in charge must be notified of the charges. Okay, why? Well, who's responsible for you? Okay, there's a little place. I guess I shouldn't have kind of almost given the answer there or given the answer, but there's an important trial marker right there for you to look at that. That's your bonus. All right, just another little part to hit here with investigations is Article 4057, 720. Okay, 4057, 720. That whole section there, we're not going to spend a lot of time going through that or hardly any time going on through that, I should clarify to say, but that is the section that talks about investigations. Okay? And so it would be good for you to read through that. There also is some good information on the Real Estate Commission website that what happens if a complaint is filed against you, where you can go through and look at what happens if a complaint is filed. Now, there is on page 50, the remainder of the class, we're going to go through, and there's a scenario on page 50 of your outline to where you get to investigate. So you get to sit in the seat of the investigator and get a little practice. Okay? You have a scenario there. You can read through that scenario. Then it gives you a place for you to investigate. Okay? Give you a little time to do that, and then we'll come back. All right, what did you find? You went through that whole scenario, looked at the fact pattern. This is what you need to be able to do in your practice, day-to-day practice, is when something comes up, what do you need to do? How do you need to handle that situation? That's what this exercise is designed to help you learn to do. That's why we spent so much time on it today. It's so you can go through and practice doing this yourself, because nobody except your BIC is going to be out there. Well, I guess that's not true. There are other people that will help you, but your BIC is responsible for your conduct. But you've got to be able to cite these issues to know what's going on for yourself. All right, I thank you very much for being here today. I thank you for your attention. Hope you have enjoyed the class, a walk through the law. I am very excited about this class and all that the associated licensees should now know.
Thank you, Carol, for a wonderful presentation for us and all of the work that you did in getting this ready for the instructors. I know they're really going to appreciate the time that you took there. I also want to thank the Western Upstate Association of Realtors for allowing us to use their wonderful classroom and the equipment that we have here in order to conduct this training for you, and to thank the South Carolina Real Estate Commission as well as the staff at the Real Estate Commission for not only approving the course content and the outline, but for getting together with you pretty soon to let you know how you can qualify to teach this course. If you have any questions, feel free to email me, Diana, at dianabrothers.com, and I'll do what I can to answer those and make your teaching of the 2020-2022 core course, a walk through the law, even easier for you. Thanks again for your time, and I certainly appreciate your attendance.